I rise in strong opposition to the bill before us, House Bill 5468, an act concerning the provision of so-called parent-managed learning. This bill is not merely about homeschooling, as most people have referred to it. It's about something much, much larger, which is the relationship between the citizens of Connecticut and the state. And the question really is, are we citizens or are we subjects? Because citizens have rights. Subjects have only permissions. Citizens raise their children while subjects wait for the government to approve their choices. Citizens direct the education of their children. Subjects are told that the government will decide, and parents may merely manage what the state allows. I want to just pause for a moment and say that I don't deny that there has been a number of tragedies and heartbreaking cases in the state of Connecticut, especially recently involving children. And every member in this chamber should care very deeply about child safety. Every one of us, wants DCF to do their job, to follow the warning signs, to verify information and protect children that are actually in danger. But the question before us is not about whether children should be protected. Of course they should. The question is whether government failures should become the excuse for government to take control over innocent families, and that is exactly what House Bill 5468 does. It starts off by changing the wording of the current law. It changes the language from parent-directed education to parent-managed learning. That's on line 48 of the bill. And this new statutory term matters very much because it does not say home education, it doesn't say parent-directed education, it does not say family-directed education, it says parent-managed learning. And that's a bureaucratic phase. It suggests that the parent is not the primary authority, but merely the manager of an educational arrangement that is recognized and monitored by the state of Connecticut. Parents are not middle managers between the state and their children. The state does not create the family. The state does not own the child. The state does not grant parents their natural responsibility to raise and educate their own kids. Parents do not manage their children on behalf of the government. It goes on to create a compliance structure around the subject of parent-managed learning. The current framework, our current law, which is understood by everyone here watching, and the many people that I know that have reached out to me over the last couple of hours who are watching online, is that parents are responsible for the education of their children. This new framework says that the parents must fit into the state supervised category and comply with the state filing and clearance requirements. In other words, that the state will now be the decider. It converts what has long been an understanding that parents are responsible for what happens with their kids to a government-regulated status. It creates this new intent to educate form, which will start in July of 2028. This applies very broadly. It's not limited to families where there's actually a safety concern. It's not limited to families with prior truancy problems. It's not limited to families where DCF is involved. It is anyone who wants to make an alternative educational choice. And the people that support that are trying to minimize it. It's just paperwork. It's not important. We already do most of this. I see a shift in presumption. A free citizen should not have to file an annual report with the government just to say that I've made a decision on how I'm going to educate my kid. Rights should not have to be renewed every year like a permit. So I want to start with a few questions, Madam President. The first one I would ask is who keeps these forms? And how long are they retained? And who has access to them? Through you.
Thank you, Senator McCrory.
Through you, Madam President, the school system will keep the form and they'll be retained as long as the child is being educated by their parents. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Maybe it's my ears, but I could barely hear the gentleman. Maybe he could just speak up a little bit more through you.
Thank you, Senator McCrory.
Through you, Madam President, the school system will keep the forms and they will be retained as long as the child is being educated at home by their parents. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate that information. I also asked who has access to them, and I would add to that, can they be shared? Can they be shared with other state agencies? Through you.
Thank you, Senator McCrory.
Through you, Madam President, the withdrawal form can go through DCF. Other than that, no other agency will be able to share that information. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. That is all for that section. My concern is that these forms, once they are in the hands of the school district and maybe DCF, as was mentioned, are going to later be used to justify even more regulation. As it is, this policy that's before us is going to require school districts to pursue families who fail to comply and provide the necessary forms. The way I'm reading this is that the school district will make 3 attempts. If that cannot happen, the board must notify the Department of Education. What we're seeing here is like a chain of escalation. We go from the parents required to go to the school district, and now the school district's supposed to follow up with them, and then it goes to the Department of Education. And then what's the next step after that? What happens after the Department of Education is notified? Through you.
Thank you, Senator McCrory.
Through you, Madam President, that information is not clarified in the bill. After the 3 attempts are made, information goes to SDE, and at that point, SDE has the information, and there's nothing else that addresses that concerns at that point. Through you, Madam President.
Thank you, Senator Sampson.
Well, thank you very much, Madam President. I appreciate that. I mean, what's the reason, though? Is it the bill just unfinished? Are we going to come back in another piece of legislation and specify what happens once SDE has this information? Is the family placed on a list? Is there an investigation? Is DCF then notified? What happens? Through you.
Thank you, Senator McCrory.
At this point, through you, Madam President, at this point, SDE can use its professional judgment on what should happen next. Clearly, what we have is a child out there wandering. We not know if they're being educated in public school, private school, or home managed. SDE will have to make a decision on what should be the next steps. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. This is how our freedoms are converted into compliance. First, it's a form, and then it's a follow-up, and then it's a notice to the SDE, and then who knows? Then DCF's knocking on your door, or maybe it's the police. Maybe there's penalties. This bill also treats private school withdrawals differently than homeschool. So the way I understand the bill, it says if you are a parent and you are going to send your child to a private school, you are required to show up at the public school, sign a withdrawal form, and provide evidence that the child will attend a non-public school. Once that's done, withdrawal is approved, easy peasy, right? But if the parent is withdrawing the student from the public school to homeschool, that withdrawal is not effective until the superintendent approves of it, and they have to do a DCF records check to get that approval. Guilty until proven innocent. So why the disparate treatment? Through you, Madam President.
Thank you, Senator McCrory.
Well, through you, Madam President, once again, I kind of answered this earlier. When the child's in a public school, you have many adults who are what we call mandated reporters, who are required to do whatever needs to be done to make sure that child who is not in a safe environment, DCS is informed of that. Now, however, that child is in the hands of the adult who's going to be the parent manager, and therefore there's no other eyes on that child. So therefore there's another form of supervision that has to take place. And I also mind you that we do background checks on teachers. So now that the parent is going to be the teacher, same procedure is required. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. You know, I kind of had a line of questioning laid out here for how I wanted to proceed, but I have to tell you that I am just stunned by the way this is going. I mean, frankly, I'm just stunned. Because the idea here is somehow that if the child is in touch with a school, whether it's a public school or even a private school, somehow they're safer than they are with their own family. That's the argument that I'm hearing. It's the most illogical argument on the planet. The fact is that the parents, the families of these students, are the reason why we have a state government. They are the reason why we are elected here to serve them and create policies for their benefit. And they're the reason why we have even a DCF and mandated reporter legislation, as was just described. Because it's the parents of the kids that are concerned about making sure that they are looked after when they're outside of their care, custody, and control. And now what we're hearing is that the government thinks they possess the kids and they want to be concerned when the kids are outside the government's care, custody, and control. It's crazy. And what's funny about this is it's so obvious the way this policy is written that the people that wrote it have absolute disdain and hostility for homeschoolers. Because they wrote a policy that basically creates completely unequal treatment. Both of those choices remove the child from the public school system, but only one of them creates this mechanism where there's a DCF check. This is not just about accountability for whether or not there's an education going on, as has been implied. If it were, the private school and the homeschool would be treated the same, but they are not. This bill singles out people who want to homeschool. And the reason why they're doing it is not because they're trying to regulate risk. It is because homeschooling is not a favored choice of this state government and this majority. Can I ask why and I might get the same answer, but through you, Madam President, why is it a family that chooses to send their child to a private versus a public school are able to avoid the DCF check? Through you.
Thank you, Senator McCrory.
If I'm understanding the question correctly, when parents choose to take their kid out of public school and put them in private school educators also have to go through a background check. And again, you have a public school teacher, you might have a private school teacher, and now the new teacher is the parent. So therefore, everyone's going through a check through you, Madam President. I think that's fair for everyone.
Thank you, Senator Sampson.
Thank you very much, Madam President. I certainly respect the gentleman's answer, although I couldn't agree more. The parent doesn't need to go through a check. The parent brought the child into the world. The parent raised the child. The parent provides for the child. The parent makes sure that they are getting adequate education, whether it is from them or from the public school or the private school. They do not need the help of the majority party in the state of Connecticut. This bill also requires DCF records check for everyone in the household. And I was listening to the very interesting questions that were posed by Senator Summers, which were outstanding questions, by the way, because none of this makes any sense to me. Because suppose you do a DCF check and DCF says no. What happens then? Through you.
Senator McCrory.
If DCF says no, clearly there's an individual, it may not be the parent, who loves their child, but there's an adult in that household who is on a registry, is a registry of neglect and abuse. And therefore, we do not feel as comfortable enough of placing a child in the hands of someone who is on a registry, and I mentioned earlier, why would they be on the registry? There are some current issues that's going on, and no one, in my opinion, wants to put a child in the harm's way. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I genuinely appreciate the gentleman's response, and I share his righteous indignation that somehow a child could be harmed by someone that might be on such a list. So why? Well, let me ask the question again. The question I ask is, what happens then? What happens then? Through you.
Thank you, Senator McCrory.
If through you, Madam President, what happens if, again, you go you do the query, nothing comes up, you can educate your child. If you choose, if something does come up and there's a problem, there's someone on the registry, and you choose to continue just to homeschool, then there's nothing in this piece of legislation that addresses that concern. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I appreciate the gentleman's answers because he's got to go by what's in the bill, which it doesn't tell us. But my assumption is nothing. Nothing happens. The child is still going to be home living with their parents and presumably the person that's on the list. Am I right about that, through you, Madam President?
Thank you, Senator McCrory.
Through you, Madam President, absolutely.
Thank you, Senator Sampson.
Okay, so this is absurd. So we're so concerned that this family might have someone in the household that doesn't meet the approval of the state of Connecticut, so therefore they're not allowed to homeschool, but yet the child's still going to be living with the same family, and the state will do nothing about that. The whole thing is crazy. The assumption that the kid might be safer in a public school, to me, is the first ridiculous assumption. I watch the news every once in a while, doesn't happen every day, and my wife's a school teacher, so I'm not down on teachers by any stretch of the imagination, but every once in a while we find out that some school teacher is not exactly treating their kids the way they're supposed to. And I suppose that's true across the board. The majority can probably point to cases where parents have abused their children, but anyone can point to situations where kids have been abused in private school, in public school, outside of school by a neighbor, at band camp. Who the heck knows? We should be going after that behavior, and we should be worried about protecting children instead of setting up a bunch of ridiculous guardrails here that do nothing. What happens, through you, Madam President, when the kids are not in school? What happens during a child that's in public school because they're not approved, because the DCF check said, no, you can't homeschool? What happens during the summer, for example, when that child is home with their family for several months? Through you.
Thank you, Senator McCrory.
Through you, Madam President, currently there's nothing the school can actually do during the summertime. That's current law, and that will continue that same way. So therefore, if there's a child who has a parent or some adult in the household who's on the registry and it's summertime, we won't know that information. That's just information we just won't know. Through you, Madam President.
Thank you, Senator Sampson.
Thank you. And the gentleman said a little while ago that there were 30, I believe, cases in Connecticut where there are folks that turned up to be on this abuse and neglect list where folks are homeschooling. Am I correct about that, through you, Madam President?
Thank you, Senator McCrory.
Through you, Madam President, that's absolutely correct.
Thank you, Senator Sampson.
Thank you very much, Madam President. What is the state doing about that?
Senator McCrory.
Well, currently the state is not doing anything about it because we don't have a law in place that the state can come in and do anything about it. But as we move forward, hopefully that would not take place because that child would not be able to be homeschooled if there's someone on the registry. Through you, Madam President.
Thank you, Senator Sampson.
Is there anything in this bill that attempts to address that issue, through you?
Thank you, Senator McCrory.
Through you, Madam President, no, because once again, those parents and children who are being homeschooled right now are currently grandfathered in. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much. I appreciate it. So there you have it. We're going to create a database of folks that are denied from homeschooling because of the potential that someone who is on a list is not approved by the state of Connecticut. And we could come up with many, many very legitimate reasons that might be concerning, but we could also come up with a lot of reasons that might not matter one bit. I also don't know if there is such an extreme certainty about our public or private school systems in the state of Connecticut that would guarantee that none of those folks that are on that list would come in contact with children either. I tend to doubt that that's a fact. The whole point here is that parental rights are fundamental. The right to direct the upbringing of one's child and to direct their education is not supposed to be denied because you're in a database. A database is not due process. Can I just ask what someone has to do to end up in the database that is being created if there is a block created for parents and they're not allowed to homeschool? What is the standard for someone to be placed on this registry? Is it a criminal standard? Is it beyond a reasonable doubt? Is it clear and convincing evidence? What is it? Through you, Madam President.
Thank you, Senator McCrory.
Through you, Madam President, the standards are already in place. There's laws that will place someone on the registry. Clearly, they have to do something that has harmed the child. We're not creating new laws or recommendations or standards moving forward. We will clearly have already laws in place that determines whether and why an adult will be on the registry. So we're not creating something new. We're just codifying what we're already doing. Through you, Madam President.
Thank you, Senator Sampson.
Well, thank you very much. The reason why I'm asking is because I'm just curious how someone ends up on this registry. Do they have to have a conviction? Do they need to have some sort of finding of guilt? Or can an allegation be enough? The neighbor said something was happening. Through you.
Thank you, Senator McCrory.
Through you, Madam President, DCF will have to do a finding and find out exactly what the issue was substantiated. That means they did their research, they came up with a decision that placed a person on the registry. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much. Madam President, can the gentleman point to me where in the bill it says that there has to be a finding of guilt or anything beyond a mere investigation? Through you.
Thank you, Senator McCrory.
Again, the DCF's process is they do an investigation. And if the investigation is substantiated, that individual goes on the registry. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Again, I don't want to be a pill, but I don't see anything in the bill that says that there has to be anything that is substantiated beyond an investigation.
There's an open case. They can't homeschool.
Right. Yeah. Oh.
Senator Sampson.
Thank you very much. I was asking for where in the bill it says this. Through you.
Oh, apologies. Senator McCrory.
Through you,
Sorry
Madam,
about that.
Through you, Madam President, that's existing law. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. I guess I'm not going to find that out. Well, I mean, if the good gentleman can maybe tell me the statute or something like that, and I'll give them a little while to work on it. But my concern is this: anyone can be accused. You know, you could have a disgruntled relative. You could have a divorce situation where people are suggesting that the other person is abusive to their child. You could have a school employee that is angry that the child's leaving the district. You'd have anything. You have a person with a grudge over anything. And once that investigation is opened, the parent's ability to withdraw the child is blocked immediately. And I don't believe there's anything in the bill that says it has to be substantiated, and certainly not substantiated beyond a finding of DCF, who in that particular case would be the judge and jury of whatever was going on. An allegation is not proof. An investigation is not guilt. A suspicion is not a constitutional standard. What happens if it's later overturned? Even if it is substantiated? I would ask the good chairman of the Education Committee, what happens then? Does the family get their rights back retroactively through you?
Thank you, Senator McCrory.
Through you, Madam President, first, the statute is 17A 101K, and if they find out that the investigation is not substantiated, then nothing happens. If they find out it is substantiated, I'm not quite sure, the child will not be able to be homeschooled. But if they go through the investigation, it's not substantiated, you can homeschool your child. Through you, Madam President.
Thank you, Senator Sampson.
Thank you very much, Madam President. Yeah, I'll take the gentleman's word for it about the statute, although I am pretty convinced after reading through this a number of times that a mere allegation would be enough to block a withdrawal from the school district. And my concern about that is that even if it's temporary, what we're doing is we're suggesting that the parent is guilty until proven innocent. And I'm not okay with that. I understand that we might be concerned about a child's safety, but I think you'd have to have a little bit more than a presumption that simply someone is on a list. This whole thing creates a prior permission type system. Basically, the parent can't withdraw the child because they say so, which is the way everyone in this room, outside the majority, understands the way our world works, that the parent is in charge of their children, and they should dictate and direct their child's education. This basically says that a parent's decision is not operative when the parent makes it. It only becomes operative after the superintendent approves it, and that's only when the government says so, when DCF gives its blessing. That is not notice, that is permission. I have a problem with the notion that someone's rights as a parent only begin when the superintendent says yes. We could go on for quite a while talking about the due process aspects of this bill. I notice also that it creates this parents managed learning data to the statewide education data system. Can the good gentleman tell me what that's about? Why are we keeping this data through you?
Thank you, Senator McCrory.
Through you, Madam President, it just gives us information on where students are being educated, whether it's in our traditional schools, our private schools, or parent-managed instruction. Through you, Madam President.
Thank you, Senator Sampson.
Through you, Madam President, what kind of data is being collected? I mean, is this individual student data, or is it only like aggregate numbers? Are there going to be records about each family through you?
Thank you, Senator McCrory.
Through you, Madam President, aggregate numbers. We just want to know where our kids are and who's educating them. Through you, Madam President.
Thank you very much, Madam President. I just want to suggest one more time that the gentleman keeps referring to this as our children. The government, they're not the government's children. These are the children of the parents, many of whom are with us today. And frankly, I find it objectionable, with no disrespect to my colleague, that they keep being referred to as our children. I'm concerned about this database because sounds like the beginning of a lot of other databases that have been created throughout history. And once there is a database, there is a way to track information. And then there's a count, and then there'll be a curriculum created that has to be followed, and then there'll be assessments, and then there'll be home visits, then there'll be approval standards, and then there will be some sort of enforcement. This is why people are concerned. They want to maintain the control and power that they have now to dictate their own lives and the lives of their families. They do not want it replaced by a government that thinks they own the children. And they are not paranoid. They're simply paying attention. I think I'm just going to wrap up, Madam President, so I'll let the good gentleman relax. No more questions. This issue has been with us for the last couple of years, but it really reached a significant level of energy and caution earlier this year. And I've been in contact with a great many families that homeschool their kids. And I've heard their personal stories. I have seen the fear in their eyes. I have seen the dramatic level of concern that people have expressed when they've come here to this building, something they thought they would never have to do, simply to raise their own kids. I want to tell those folks that you are not wrong that you feel targeted. You're not wrong to feel insulted. You're not wrong to feel that the state is treating you like you're suspicious. It's all happening. I'm watching it too. It's extremely concerning. And I understand that people homeschool for a lot of reasons. They homeschool because they believe they can give their child a better education than the state of Connecticut. And certainly, if you live in some communities in the state, I don't think that's an argument that the state could win. Many people homeschool because the school district just doesn't have the ability to meet the child's needs, or because of anything else, bullying, special needs, some of the things that are taught in public schools in America today, things on sexuality, gender ideology, DEI, race politics, you name it. Things that parents, free citizens, find objectionable. So they are exercising their right to homeschool so that they can raise their kids the way they want to. That does not make them dangerous. That does not make them extreme. They're just parents who want what's best for their own children. And I want to be honest about something that I've said a number of times, and I've got to be careful because in this chamber we have to be focused on policy and not motive. But I have seen a series of policies put together that very clearly target populations in this state simply because more often than not, they do not support the majority party in this state. Gun owners, people concerned about religious freedom, and yes, homeschoolers too. That hostility shows itself in this bill. It shows up in the language of the bill. It shows up in the unequal treatment. It shows up in the DCF checks. It shows up in the presumption that people that want to homeschool their very own children should be monitored, cleared for approval, tracked and checked upon. And that is where my concern and my sympathy and empathy for the people that are faced with this turns into anger. The more you read the bill, the more clear this becomes. Not to mention the fact that this bill does nothing about the tragedies that we keep being reminded of that are supposedly the reason why this legislation is here. This bill does absolutely nothing to fix DCF. Doesn't create a better follow-up, doesn't create a better investigation, doesn't ensure better identity verification. It does not target actual abusers of children. Instead, it targets a category of families. And when the government is using a tragedy to target innocent people, my sympathy turns to anger. We are being asked to accept a very dangerous bargain, that we should trade long-standing parental rights for bureaucratic oversight. And we are being asked that because some parents might do evil, that every homeschool family should be a suspect. It asks us to believe that an allegation can block a right, that a DCF database can substitute for due process, that it can treat private school families different than homeschool families. And it asks us to believe that parents are not the ultimate authority over their children unless the state of Connecticut says so. I reject that. Like anyone else, I want children protected. I want abuse to be stopped. I want DCF to do their job. I want real warning signs to be followed by the DCF caseworkers. I want those failures to be investigated. I want children in danger rescued. But I am not going to blame the families that want to homeschool for things that they have nothing to do with and they did not cause. I'm not going to allow those tragic stories that Senator Berthel described to us earlier to become the cause for surveillance of innocent people in this state. I am not going to sit by and let parental rights turn into government permissions. The family is not a department of the government. Parents are not subjects, they are citizens. And they do not need the permission of this state government or anyone in this room to educate their own children. Thank you, Madam President.